Good morning. Welcome to the second Saturday series for Sanchez Law Firm. I'm Benjamin Sanchez. I'm a Texas consumer attorney, and every second Saturday of the month, we present a webinar on a topic that may be relevant to you and your claims. In today's webinar, we're going to be covering the issue of mitigation of damages. Now, those are fancy words, but basically it means how do you minimize how bad you are hurt? And a defendant, if you sue someone, a defendant gets to claim that you did not minimize your injuries as much as you should have. Therefore, you should not get compensated or paid for all of the injuries or damages that you claim. Now, the idea of damages is very important in the law. In law school, law students are taught about the three-legged stool of a legal claim. One would be liability, in other words, who's at fault. The second one would be damages. How much are you injured? How were you injured? And then the third part of a legal claim would be collectability. So, for example, a lawyer may have a good liability claim, may have high damages, but if they're going against a broke defendant, then it may not necessarily be a good claim. Or there may be a defendant who has money, and there may be a claim. In other words, there was fault, but the client was not damaged that well or that much. So the amount of the claim is very small. So damages is one of the stools of a three-legged legal claim that a lawyer uses to evaluate any potential plaintiff's claim that comes in the door. The law also requires that people make some effort to minimize their claim. That means that if you are hurt by someone else, you can't just allow yourself to be hurt forever or increase your injuries just because someone hurt you. You have a duty yourself to try to recover and minimize those damages. Under Chapter 33 of the Texas Civil Practice and Remedies Code, there's even the law of proportionate responsibility. And that law says that if you are 50% or more responsible for your own injuries, you don't get anything. Now, what I'm going to talk about today is the mitigation of damages, which is a specific kind of defense that a defendant can use and that a plaintiff should know about so that when you're thinking about your legal claims, you do something in accordance to the law. Now, under the law of mitigation of damages, the plaintiff actually has a legal duty to exercise reasonable care in minimizing damages. And we'll get into specific examples of all this a little bit later. I kind of want to go over what the plaintiff must do, what the defendant must do, for the court to consider this. It could be a judge, it could be a jury, but there are issues here that I want to talk about so that if you go to court by yourself or you have an attorney, you know what to look for. Now, the plaintiff, so apparently my jacket that's good. Sorry guys, it's live. Someday we'll get this right. The plaintiff is required to mitigate damages if it can do so, but it must do so only with slight expense or reasonable effort. So you don't have to go through the ends of the earth to mitigate your damages. You don't have to spend an obscene amount of money to mitigate your damages, but you must take reasonable efforts to mitigate your damages, and you may incur some expense. And actually, I'll get into this later, you can get paid for the expense in minimizing your damages, assuming that those damages were minimized, because it may be cheaper to minimize your damages than to just suffer the damages that you would have suffered if you had not done so. So if you minimize your damages, you actually do have the right to recover the cost of those. A quick example may be if you get into a car accident and your car is in the shop, you may have to rent a car to then go to work, right? And so that way you don't claim a loss of employment due to the car accident. You could get reimbursed for the car rental as part of your claim because you minimize your damages in not having loss of income. So that's a quick example of minimizing your damages. Now, if you do not minimize your damages, then you are not entitled to recover those damages that you could have minimized. Okay, so going back to this car example, you cannot claim a loss of income for your job if the only thing that stopped you was having a car and you could have rented the car. Now, sometimes you may not be able to rent a car if you don't have the funds or whatever, but you have to make sure that you at least try. We had one person come to our office who claimed they were in a car accident and the car's in the shop. What that person did, however, instead of renting a car on a weekly rate, they took Uber everywhere. And those Uber costs were high and they kept rising and rising and rising. And so I think in a month they were claiming like $4,000 in Uber costs when it could just take you, $500 or, $1,000 at most to buy a used car or rent a car or something. So you're not entitled to get all of those costs because it was unreasonable for that to happen. If you hear the word avoidable consequences, if you're talking to an attorney and someone talks to you about avoidable consequences, it's the same thing as mitigation of damages. Again, it's just minimizing the harm that's done to you. So you have harm, but then you want to minimize that harm. What's the purpose of this kind of legal rule? Well, it is to discourage people from wasting away or unnecessarily increasing damages. You think about this in the age of insurance. Insurance obviously is there to help you, but the insurance companies certainly don't want to pay for all of your damages if you could have helped yourself. So, and you, even if you don't have insurance, if you're someone without insurance, you yourself might look at someone and say, hey, you could have done something to help yourself so that I wouldn't have to pay as much. And when you don't do that, that's a problem. So the law tries to discourage people who get hurt from sitting there and wasting away and not doing anything to help themselves. Now, the duty to mitigate damages comes up in all sorts of legal actions. There are contract actions where you have agreements. If someone fails to do something, you have a duty to mitigate your damages when the other side doesn't breaches that contract or doesn't uphold the contract. You also have a duty to mitigate your damages when you're hurt by someone's actions. When does that duty to mitigate arise? When does that duty to minimize your harm arise? As soon as you know about the event that caused damages. So if it's something that happened to you, then pretty much right away. If it's a physical event, then as soon as the car accident happened that you need to mitigate your damages. If if a tree falls on you or whatever, if something harm comes to you, then you know it. Now, it may be that some damages claims you don't really know about, right? You discover them later because it's a breach of contract or whatever. So you don't have a duty as soon as it happens. You have a duty as soon as you learn about the conduct in which there may be damages. It's also important to know that you don't have to know that there are damages that you're suffering. You just have to know about the conduct that could lead to damages. So in other words, something happens, you think, oh, well, this might happen. I might lose damages about this. You may say, well, right now I don't know that I've lost any money or anyone's been hurt. So I'm not going to do anything. No, the law says as long as you know about that event, and that event could lead to some harm, money damages, physical damages, then you have a duty to mitigate your damages. Now, it's important to know that if you are the plaintiff and someone wants to mitigate their damages, okay, and let's say they want to pay you for whatever harm was caused by a breach of contract, or at least they want to mitigate their damages in some way. If the defendant, the person who caused the harm, is conditioning the mitigation of damages offer to say that, okay, you will drop your claim if we give you some sort of mitigation of damages, you do not have to take it. In other words, you are entitled to your claim and to go for damages, but you also are responsible for mitigating your damages. Someone just can't say, well, I'm going to pay you. Let's say there's a landlord that is owed rent, and the rent is $5,000, and the tenant says, well, I'll pay you $2,500 to not go forward on the eviction. You don't have to say, well, because he offered $2,500, I can't go forward on the eviction. You can take the $2,500 to minimize the amount of damages to you, but you are still allowed as a landlord to go after the eviction, even though there was an attempt to minimize the damages that the tenant that you suffered as a result of the tenant's failure to pay. I have a case right now, for example, where I represent a special manufacturing company, and they're a fabricator of specialty commercial equipment. And there is an allegation that my client, the fabricator, failed to meet the contract to provide a special component to a client. Now, in that case, my client is offering to do something that is not in full satisfaction of the contract, because they just can't do that, but they're willing to provide some part of it, of the equipment, and then have the other side then get the remaining part from someplace else. So they're doing their part to try to minimize their damages. And so we think that case is probably going to get resolved, but if it doesn't get resolved, that is a defense that we can use, that we try to mitigate the damages by doing some part of the contract. And that can be shown in front of the jury. Now, this is a legal theory that I've been talking about. How does it play out in reality when you're actually going to court and you have a lawsuit? Well, the mitigation of damages is what we call an affirmative defense. And in law, when you file a claim in a court, you have a lawsuit or a petition, and in that petition, you have to list causes of action. Those are the legal reasons as to why the other person has caused damages to you, how they've hurt you, okay? So there may be negligence, may be breach of contract, maybe all sorts of things. Well, when the defendant answers the lawsuit, they are allowed to present their own defenses. One, the most often used one is called a general denial, where the defendant just says, we generally deny the facts that you allege or that we've caused you damage, and you can go that way. But the law does say if you have certain special defenses that you want to use, you must put them down in your answer. You must, in effect, plead them so that the plaintiff knows that you're going to plead them. And the mitigation of damages, the failure to mitigate by the plaintiff, is such a defense. So that is something that must be pled in your answer before you can put any evidence of the failure to mitigate on at trial. And if you fail to do that, then at trial, you will not be allowed to put on evidence in front of the jury or the judge about the plaintiff's failure to mitigate damages. So again, going back to our car accident example, if there was a car accident and the plaintiff sues the defendant for the car accident, but let's say the plaintiff did nothing to try to get a job and just waited on the car repair, or let's say the plaintiff had a job and the car was in the shop, and the car was used to get the plaintiff to and from work. But now the plaintiff did nothing to try to get to work, either by cab or by Uber or renting a car or friends or family, and ultimately lost the job because of their failure to go to the job because there was no transportation. Now, if you as the defendant don't put in your pleadings that the plaintiff could have minimized their damages, could have saved their job, could have rented a car or whatever, if you don't put that in your answer, when it gets to trial and you discover, whether before or at trial, that the plaintiff just sat there and watched soap operas all day and did nothing to help himself, you cannot put evidence on that that's a failure. The jury can't even consider it because you never pled it. So it's important to make sure you plead that if you think that's the case. Now, I generally advise people to have attorneys when cases go to court. Of course, we have the Justice of the Peace system in Texas that is really designed for people to affect their own legal representation if they want. But there are these sort of subtle things that are in the law that you may not know about. And if you don't know about it, it could really affect you. So I certainly urge you to seek an attorney and one who's familiar with both plaintiff cases and defense cases. Here at Sanchez Law Firm, we represent both sides of cases. We represent non-commercial landlords, we represent tenants, we represent people who breach contracts and people who are sued for breaching contracts. We have a little bit of collection, and then we have some defense as well. Now, not only do you have to plead, if you're the defendant, not only do you have to plead the mitigation of damages, you also have the burden to show that the plaintiff failed to mitigate their damages. So you can't just plead it and then say, okay, well, it's up to you to say, you plaintiff, to say that you mitigated your damages, because you plead it and then you have the burden to prove it. And what's the burden? Well, you have to show that the plaintiff did not use ordinary care in reducing or avoiding its damages. Again, the plaintiff does not have to go through extraordinary measures or extraordinary expense to try to minimize its damages. And this is almost like a case-by-case basis. So let's just say that you were, you had a specialty job and something cost you your job in one part of the country. And your job was so specialized that really the only other way to get a job like that, other than remote, is to move to the other side of the country. It's not reasonable to expect you to pick up and change your entire life and move to the other side of the country to try to get that job. It is reasonable to for you to try to get a remote job if you can't get a physical job that's a really specialized kind of job. So there are things you have to consider. What's the amount of reasonableness? Well, that is going to be up to a judge or a jury. So that is a fact issue that the judge or jury has to determine when they're considering the case. But that is something that will be considered at trial. It's not something that really can be done by what we call a summary judgment evidence. So for you lawyers out there, you know that you can end the case before it ever gets to trial by filing a motion for summary judgment. However, if there's a fact issue on the mitigation of damages, then you're not going to get a summary judgment on that issue. Now, in order to get a jury instruction, so in order to have this mitigation of damages issue that you've pled, okay, first you got to plead it, and that you've shown evidence of in court, in order to get a jury charge on it, you must show two things. The defendant's evidence must clearly show that the plaintiff's decision not to mitigate caused further damages. Okay, so if the failure to mitigate did not cause any additional damages, then that's not really a big issue, right? Because the failure to mitigate didn't really cause anything more. The failure to mitigate is an attempt to try to reduce the damages. So if you can show that the damages would not have been reduced, even with an attempt to mitigate, then you don't get an instruction on the failure to mitigate. And then furthermore, the evidence must sufficiently guide the jury in determining which damages were attributable to the plaintiff's failure to mitigate. In other words, you as a defendant are really going to have to show evidence that said this particular lack of mitigation caused these damages. It's not enough to just try to throw something on the wall and just hope that the jury figures it out. You really have to guide the jury to say, because the plaintiff failed to do this, it caused these extra damages that would not have been there otherwise. And therefore, jury, we should not be responsible. You should not make us responsible for these additional damages. And again, I'll go into some more examples in a little bit. Now, what type of evidence is the defendant supposed to present in order to show this mitigation of damages? Well, the defendant is only required to present some evidence from which the jury can make a reasonable calculation of the losses caused by the plaintiff's decision not to mitigate. In other words, the jury has to be able to figure it out. I mean, if you just say, well, the plaintiff did X, but there's no way for the jury to figure out how X causes a specific amount of damages, it's going to be very hard for the jury to say, well, let's just make up a number and try to figure out what those damages might be. Again, if you're talking about the loss of income, right, you can show the loss of income or the fact that they would not have lost that income had they done something else. Again, the car example is always, I think, a very easy one for most people to get. So, if the plaintiff is saying this car accident caused me to be out of work for a month, I didn't have transportation to and from the office or the job site, well, then, if you can show that had the plaintiff been able to get some other kind of transportation, let's say it may have taken them a week to get that transportation, you could argue that those 3 weeks of the lost income should not be applicable because the plaintiff failed to mitigate the damages. Okay, so you have to be able to show what damages arose from the plaintiff's failure to mitigate their damages. Now, the defendant does not have to prove an exact amount of the damages, okay? The defendant just has to show the jury or the judge a reasonable pathway from the failure to mitigate to specific damages. And then it's up to the judge or the jury, whoever's trying the case, to then determine the amount of damages. When you get into the legal case itself, it's a little tricky. Now, if you are handling JP cases by yourself or you're your own attorney, remember you have to plead the failure to mitigate in your answer. So if you're filing an answer and you're doing it yourself, write down these words: plaintiff failed to mitigate his or her its damages. Okay. Now, some courts have held that sometimes that may not be specific enough because Texas is what's called a fair notice state. So if someone looks at your pleadings, they generally should be able to tell from your pleadings what the basis of your claim or defense is. A lot of times, I, as an attorney, see a list of affirmative defenses that are pled by defense counsel. They will say X, Y, Z. They'll just say, failure to mitigate, proportionate responsibility, whatever the case may be. And we can specially accept, so that means we can complain to the court that is not sufficient to give us notice of the basis of that defense. So generally, when we plead an affirmative defense of mitigation of damages or failure to mitigate, we like to include extra language as to why we believe or what the failure was, right? So the failure to mitigate damages in that car accident case is the failure to get replacement transportation to keep the job so that they can continue working, right? So just something like that. The discovery process in the lawsuit will get into the specifics, but you should be able to plead that. Now, if you are the plaintiff and you get that kind of general pleading, then you can complain to the court through something called a special exception. It's a special kind of document where you say, hey, court, the defendant pled this affirmative defense of failure to mitigate, but I don't know the basis of that failure to mitigate. I at least need some notice. And you can then have a hearing on that, and then the judge can decide whether or not the defendant should put a little more meat on the bones of that failure to mitigate. Normally, most attorneys just go through the discovery process, and that's where they pick up that extra information. But technically, you could ask the court to have the defendant clarify the basis of the affirmative defense within the answer itself. So just as a reminder, remember you must plead the affirmative defense in your answer. You must write it out in your answer. And then you as a defendant also had the burden of proving that the plaintiff's damages could have been minimized or mitigated if the plaintiff had taken certain action. So it's not for the plaintiff to say, well, no, we were hurt and we also mitigated our damages. Right? It's up to the defendant to make that part of the case and then to put evidence on. And then, the plaintiff can then say why they did or did not mitigate their damages. But it's up to the defendant to make it an issue in the lawsuit. The other thing is that you can't present evidence in a lawsuit, in a trial, if you do not plead the failure to mitigate. So again, if you figure out at some point before trial that there was a failure to minimize, the plaintiff did not minimize the damages, but you didn't update your answer, you didn't file what's called an amended answer with the court to include that affirmative defense, then you will not be allowed to put on evidence and make that claim in the trial. So it's very important, even though it's a fundamental idea of law that the plaintiff has a responsibility to minimize their damages, it's not the plaintiff's duty to make that an issue at trial. I'll give you a similar example in another defense so that you understand. There's an idea called the statute of limitations in the law. That means that you have a certain amount of time to sue someone for a particular claim. It may be 2 years, it may be 4 years. In different states, there are other things, but in a typical breach of contract action in Texas, you have 4 years to sue. In a typical tort, personal injury, consumer law claim, most of them are 2 years. Let's say the plaintiff sues on a consumer law claim under the Texas Deceptive Trade Practices Act, filed that suit 3 years after it happened, and the limitation is 2 years. Guess what? The plaintiff can still go forward if the defendant never brings it up that there is a limitation of 2 years to sue. So if the defendant never asserts that defense, even though we think plaintiff should not be able to sue, that won't be an issue at trial unless it's brought out by the defendant. So the defendant has to plead what we call the statute of limitations, that this case is too old to be sued upon. And then the defendant has to prove that this is when this incident happened, and this is when the lawsuit was filed, and this is the law of when they can sue, right? The same thing with mitigation of damages. The defendant has to plead that and then has to prove it. It's not up to the plaintiff to say, I got damage. Oh, and by the way, I also mitigated my damages as well. And if the defendant never brings it up, then it's not an issue at trial. How much evidence is required? Okay, that's a big thing. How do you meet your burden of proof? Well, the law says that the plaintiff at least has to have what's called a mere scintilla of evidence of damages in order to get damages. Okay. And then you have to, and then the burden switches. The burden switches to the defendant to then prove the failure to mitigate damages. In the law, there's this whole thing called exemplary damages, what most people know as punitive damages. Years ago, we used to call these punitive damages punishment damages. Now they're called exemplary damages. Don't know why they do that anymore. However, there's a whole separate case law and whole separate law in Texas regarding the issue of exemplary damages. And there is the issue of how to mitigate or how to prove a lack of mitigation regarding exemplary damages that has nothing to do with just your regular old damages. All right. So there is a defense of mitigation under the Exemplary Damages Act in Texas. Again, the defendant should plead that mitigation in order to offer evidence of the failure to mitigate. Okay. One of the things I think about, and if you're old enough, you may remember this, but I think it was in the 80s or 90s, there was a scare about Tylenol. So Tylenol were on the shelves of all the grocery stores, and someone, I don't know if it was more than one person, but there were complaints about the capsules not being child safe and not being able to be protected from someone tampering with the bottles before they were sold, or you as a consumer being able to show to see that this bottle was not tampered with. This day and age, we have all those kind of covers that you can see. If someone pokes a hole in it, you can definitely see that and that kind of stuff. But back then, there wasn't. Tylenol made the decision to pull all of its Tylenol from all the shelves all over the nation, okay? Because that was they wanted to use that action to show that they were mitigating the damages of the lawsuits that were being brought against them for the failure to do this and for people getting hurt as a result. So that's sort of like an extreme example of one company taking all of its products off and redoing it. The same thing that we can look at, for example, in automobile cases where there is a what's it called? The recall. Yeah, the recall. So people will automobiles will recall dealers and manufacturers will recall the vehicles to fix a particular part because they want to minimize their damages. And so the issue of exemplary damage, how much more to punish someone other than your actual losses, you can show mitigation of damages for that. You want to minimize, the law is designed to minimize the amount of unjust punishment. So there's always this balance between punishing someone but not overly punishing someone. The law says that we should punish someone for their bad acts and they should be responsible and be taught a lesson. But at the same time, we can't go too far. So there's just always this balance and this tension between a claim and damages and, the failure to mitigate or the unjust punishment. When you talk about the failure to mitigate for the purpose of exemplary damages or extra damages, there are two types of evidence that can be shown. One is the evidence of profitability of that conduct that you're suing for. So there was this case, it was an asbestos case in Texas, and the asbestos company said, well, you shouldn't punish us too much because the actual the actual profit we made on that asbestos was really low compared to what we make in other categories. And generally, our company has a negative net value because of all these claims. The Texas Supreme Court said that that was evidence that could be considered when you talk about whether or not a jury should punish that company for those extra exemplary damages. The second type of evidence that you can show that if you're the plaintiff, again, so you've now been, you're the defendant, so now you're pleading mitigation of damages. The other side, who was hurt, saying, well, jury, you should punish them. So you as the defendant can say, hey, we really didn't make much money off of that, or we have a negative net value. But then you, as the defendant, can also show that you've paid for similar exemplary damages in other cases for the same conduct. In other words, exemplary damages are meant to be beyond the individual damages of the person complaining, right? They're meant to be punishment. So if you can show as a defendant that you've been punished in other cases for the same type of conduct, you may still have to pay for the individual damages you caused in that particular case. But you could say, hey, we've already been punished and we've already paid out exemplary damages in some other case. So we've really been punished already. So please don't punish us again because it would be unjust. So those are two types of evidence that a defendant can use to try to minimize or mitigate the exemplary damages question at issue. What can you not prove? What evidence can you not use as a defendant to try to minimize exemplary damages? Well, actual damages, right? Exemplary damages are above and beyond your actual damages. So the fact that someone had actual damages has no bearing on the exemplary damages. So you can't use that to try to minimize your punishment. What can't you do? You can't say, well, we have other pending claims that we haven't paid out on, or we anticipate we're going to get this influx of all these claims. So don't punish us for exemplary damages because we may have to pay out, on these other claims. No, because you actually haven't paid out yet, right? So remember, the evidence is that you must have paid out exemplary damages in some other case. Just because you may have the claims coming against you doesn't mean that you can get away with it. The fact that you have insurance, the fact that there's insurance coverage also cannot be evidence in a case to try to minimize or mitigate damages. And you can't, for exemplary damages that you haven't paid in other cases, you can't use that either. Even if you've been sanctioned for exemplary damages in other cases, if you have not actually paid those exemplary damages, you can't use that in your case to say, well, jury, you shouldn't punish me in this case because I've been sanctioned in other cases. You have to say I've been sanctioned and I've paid in the other case. So therefore, I have been punished. It's not the theory of punishment, it's the actual punishment. Now, guys, as I tell you every week, what I try to teach you, there are entire law school classes, entire weeks of law school classes that go over these kind of things. It's really important that you kind of understand the basics, but when it comes to your individual case, you should definitely contact an attorney who knows that kind of law, and they can help you through the discussions or the ideas or strategies. For example, at Sanchez Law Firm, we offer analysis where we don't necessarily say, hey, you have to come hire us. But what we will do is we will take an hour of our time, go over your documents, and discuss with you the analysis of your case to see what issues there are in terms of the liability, in terms of the damages, what kind of options you may have, whether it's worth it to go after the defendant. And those have been proven very popular right now because people may not necessarily want to sue or want to be defended, but they kind of want to know what their rights are. And you know you get what you pay for. So if you call a legal line, it's a free legal line for 15 minutes. You know, those people can't give you their name. You don't know the authority or expertise or education or experience of the person that's giving you that advice. So one of the things we do with our analysis is we make sure that you know who you're talking to, you know our qualifications and education and experience, and that we can give you a good analysis of your case so that when you walk out the door, whether you decide to hire us or not, you understand the good, the bad, and the ugly about your claim or defense in your case. Now let's go into, I told you I'd give you some examples and I'll give you a little bit more law as well. Let's talk about landlord tenant. Okay. We do a lot of landlord tenant cases from evictions and repair and remedies and all this kind of stuff. So let's talk about landlord tenant for a little bit. Let's say a tenant moves out of the property and owes rent and breaks the lease. Okay. And let's say that, so the landlord understands that maybe there's a year lease, the tenant moved out in month 3. Okay. The landlord does have damages. Okay. But if the landlord tries to go after the tenant can show that the landlord failed to try to release that unit, whether it's an apartment or a home, that they should not be entitled to the remaining 9 months of that lease, as long as the landlord made reasonable efforts to do so. Now, it may be that the market is very low and it was virtually impossible for the landlord to release it, but the landlord is going to have to show, and the defendant will have to show that the landlord did not make reasonable efforts to try to release it. Okay, putting a sign on the front door that says for lease, right, is not enough if typically the landlord would place that ad in an internet site or a newspaper or whatever, right? So you can't just say, well, I put a sign for lease up on the window and I didn't get it for 9 months, right? When to get that tenant, maybe that tenant found you at apartments.com, or maybe you had a listing in the HAR.com, the Houston Area Realtors Association. So those are things that you have to do. So if you don't mitigate your damages as a landlord by trying to release the apartment, the tenant is not going to necessarily be responsible for all those months that you didn't get the lease. Let's take that same example. Now let's say that the tenant was paying you $1,500 a month for that lease, and you advertise and get, let's say within 2 months, $500 for that same apartment. Now you want to sue the tenant, the former tenant, that $1,000 difference that you didn't get. But you could have gotten the $1,500 because the $1,500 was fair market value for the premises, for that apartment or that home. But you chose to undersell, to underlease that home, even if it was a family member or a friend or a stranger. You didn't do what you needed to do to try to maximize your recovery and minimize the damages. So the defendant can say, hey, they only leased that property for $500 when I was paying $1,500. And maybe the defendant could say even the $1,500 was below market rate. They could have gotten $2,000 for that property. So you as a landlord definitely have a duty to try to release it at a fair market rate so that you can minimize the damages, your own damages, and the tenant gets to use that as a defense. Now let's take that example even further. Let's say that the tenant left that property in bad condition. They had holes in the wall, they had trash, it smelled, there were insects and rodents and all that kind of stuff. Okay, if you as a landlord simply attempt to rent out that apartment or that home in that same condition, you're probably not going to get many bites at the apple on that, right? And if you do, you're going to have to rent it for a lower amount. So you as a landlord also has a duty to mitigate your damages. you need to do what's called a make ready. In the apartment industry, the home industry, whenever you lease, you get that place ready for the next tenant. That may mean you have to paint. It may mean you have to clean up stains on the floor. You may have to repair holes. You may have to fumigate. But there are things you have to do to get that apartment or home ready to get the most value out of it when you put it on the market for fair, reasonable value to then get a tenant. So if you don't put it on the market, if you don't make it ready, okay, you don't lease it for a reasonable rate, all those are different instances that a former tenant can then say the landlord failed to mitigate its damages. Very important, and it comes up all the time. The other thing is we get a lot of people asking us about problems that they've experienced with their landlords over a long period of time. And I really feel for those people, but at the same time, I have to be honest with those people, and I have to ask them, why did you allow yourself to suffer those conditions for that long? You have a duty to mitigate your damages. You have a duty to get out of the situation. You have a duty to follow the law if you want certain repairs done. And that means that, for example, you have to put things in writing under the repair and remedies provisions of the Texas Property Code. You got to put your complaints in writing. You have to give them reasonable time to fix it. Then you have to put your complaint in writing again and give them additional time to fix it. Then you either have to fix the issue or you got to get out. And you have to let the landlord know in advance which of those two you're going to do. If all you do is complain to the landlord over the phone or in person, that doesn't meet the law. And so you're going to have a hard issue saying, the landlord, if you sue the landlord could say you failed to mitigate your damages because you didn't follow the law. This happens a lot in cases where there's a lack of utilities. There is sewage backup problems, in the plumbing. We see a lot of mold cases like this. I can't count how many times someone's asked me, well, I noticed that there was some mold growing, and I told the landlord about it, and the landlord didn't do anything, and it just got worse and worse, and then here we are 3 years later, and I've got breathing problems, and my child's got sick, and they think that they have this wonderful case. They're not wonderful in terms of the injuries, obviously, but they think they have a solid case because they've got health ailments as a result of the mold. But what they don't realize is they could have gotten out of that situation. And in fact, they have a duty to get out of that situation. And that's why it's very hard to prove up these mold cases. When you're looking for attorneys for mold cases, you're not going to find very many. I'm happy to do an analysis and kind of go over the issues with you. And more than likely, I'm not going to take a mold case because you have the responsibility to at least get yourself out of that situation if they won't repair the mold. So there's this idea in the law called constructive eviction. The constructive eviction is when the landlord does something that ultimately forces you, as a result of not wanting to deal with that action anymore, to leave. Under the Texas Property Code, you have to give your writings, like I told you before, you have to give them time to repair it. But you also have to tell them in advance that, hey, if you don't fix this the second time, I'm going to be considered constructively evicted and I'm going to have to leave. Okay, because I can't stay around this thing that affects my health or safety that long. Okay. And then, of course, separately, that's a separate issue, but you actually have to leave. So you can't just say constructive eviction and you're still in the home suffering the very damages that you're complaining of. So you have to then get out. And then if you say, okay, well, I'm going to sue the landlord, for this, the landlord can, there's this issue of whether or not you mitigate your damages. But you can always, there's this duty present in the law, regardless, that you have a duty to mitigate your damages. So that's, so that's the kind of, we talked about the vehicle car accident scenario. We talked about, a tenant not paying rent. Okay. So there are different ways that a failure to mitigate can come up. Let's say we in the employment context, we talk about a wrongful discharge, employee asserts a wrongful discharge claim against an employer, or there's an issue of a on-the-job injury. Okay, these come up often. We don't really handle those claims. We're not a personal injury firm. We're not a labor firm. I want to give you an example. So when you have a wrongful discharge claim, you still have a duty to mitigate your damages by doing what? By looking for another job. And we're looking for another job that can potentially replace the job or income that you had. You have to get as close as you can to what you had if you're going to say that an employer wrongfully discharged you and caused this damage. Okay. What are, you have to have extra damages as a result of the failure to mitigate. So let's say you were wrongfully discharged, but then you got a better job, right? Then the whole mitigation of damages doesn't really come into play because you actually got a better job. But let's say that I am, um, let's say you are an office manager at an accounting firm and you have a college degree. Okay. You are wrongfully discharged or you were hurt on the job. It's not a long lasting injury, but you're hurt on the job. You can go get another job. But you decide that you want to make a career change and want to take the easy life because your spouse, let's say, makes some money. So now you want to go see how it feels to work in a fast food place. Okay. And now you sue your employer for that wrongful discharge or the damages you suffered as a result of the on the job injury. Well, they get to say that you didn't mitigate your damages because you didn't try to find another job that was similar. Okay. So, you have actual damages, but then you have these extra damages that you could have minimized. And if you didn't go try to find another job that was similar to what you were doing and similar in, geography, if you want to stay there, or similar in the income, you have to try to do that. The other thing is, this happens, I think, sometimes in personal injury cases, is that people will say, well, you didn't do the rehab that you could have done in order to help you then get back on your feet, get back on the workforce, whether it's to get back on your current job or to go get another job. So, for example, someone's a delivery driver and something falls on their foot, okay, and they get hurt on their leg gets hurt, and they can no longer really walk like they should in order to do their job. If that person just puts his foot up all day and doesn't do anything to try to get better, he's not going to be able to claim as much damages, and the employer will be able to say, hey, he didn't do the rehab to try to get better, because if he had done the rehab, he could have come back to us or he could have got another job. But instead, he just made the situation worse by not doing anything. So again, that's a failure to mitigate damages if you don't do the rehabilitation to try to get better after an injury. We sometimes do dog bite cases. And so I was thinking about this. Let's say we have some neighbors who have a common fence, and the fence is really neighbor A's fence, but it kind of, it is abuts the yard of neighbor B. And neighbor neighbor B has small children, and neighbor A, who has the fence, who has got the hole in the fence, has a dangerous animal. Okay, it's known that that animal could potentially get into the yard of neighbor B and hurt the children of neighbor B. Now, God forbid that happen, but if neighbor B children were hurt because of that animal bite, one of the issues that could be pled in that case is that neighbor B could have put something to cover up that hole. They could have put wood there, hammered it, and made sure that they did their part to try to minimize the damages right? You can't say, you can't just have an open invitation to come hurt me. Now, if that dog, if you do that and that dog jumps the fence, okay, well, you can't help that. But there's going to be an issue if you knew that there was something that could cause that dog bite and you could have done something to prevent it. That is going to be an issue at trial if the lawyer or homeowner A actually pleads that. They could say, hey, they knew this hole was there. They knew we had a dog. They had children. They know that our dog is not on a leash or whatever. Now, it may seem silly, like why should that neighbor B have to do that? But that's what the law says. If you got a situation that could result in damage, are you going to send as neighbor B? Are you going to send your 5 and 6 year olds out to play where there's a hole in the fence and a dangerous dog on the other side? No, you're going to have some common sense, and the law is going to say, hey, that should be a consideration as to how much damages should be awarded against you, because you got to put yourself in that situation or you didn't do anything to prevent that situation. There are all types of damages that could be subject to mitigation. So you have lost profits in a contract, you have lost wages, you have a delay in performance. Again, if you've got a long delay, but you could have done something to shorten that delay, you have a duty to do that. If you have the ability to do substitute performance, so you have you have the ability to use some other kind of resource to do the job that you would have done with this other thing, you have a duty to do it. You get, and this is an extreme example because I just want you to get the idea. You get into a car accident that you normally use your daily driver to and from work, but you have another vehicle. You say, well, that's not my daily vehicle because I don't want to put miles on that because that's an antique. Say, well, you're not going to get away with saying, well, that's an antique. I didn't drive it, so I have all these lost wages, right? You have another vehicle, that'd be a substitute performance for that vehicle, and you could get to work doing that. Lost credit or lost finances could also be a part of that. I think that's as much as I want to cover today. I know that was a lot, but there's the concept is that if you are going to get hurt or hurt by something, you still have a duty to minimize the damages. And you can't just say, well, woe's me, I've been hurt. Now they got to pay everything for my hurt. And a lot of times I have to talk to potential clients about the idea that indeed they were hurt, but they failed to minimize their damages. They failed to get back into rehab. They failed to get a job. They failed to leave the apartment that was full of black mold for 3 years. I mean, all the sorts of things that they didn't do that they're now complaining of. Quite frankly, it would have to be a very rare and extreme case, in my view, for example, to say that you should get damages from a long exposure to mold in a home when you knew about the mold, right? If it's behind the walls, you didn't know about it, that's one thing. But if you're living with the black mold on the ceiling and the walls, and you live with that for a long time to the point that you got sick, someone's going to say, hey, you should have done something about that. Either taken that out, repaired it, or left. You don't get to sit there, breathe it in, then become sick after 3 years, and then say, oh, I need to get. Even if that apartment was a cheap apartment for you, you don't get to then later claim, well, you know, it was an apartment that was cheap, I could afford it, so I had to stay. You got to get out. With that said, let's talk about our upcoming second Saturday series. So in March, we're going to be talking about door-to-door scams and salesmen. And then in April, we'll be talking about the residential construction liability claims. So our firm does a lot of consumer law, and a lot of times we have to deal with door-to-door salesmen. To give you a preview, for example, the 3-day rule that you may think of in terms of the ability to cancel a transaction, that will apply to door, but it will not apply to a purchase where you go to someone else's business and then purchase that. Okay, so that's a little preview. Door sales, we get a lot of complaints regarding solar panels. And so we'll be talking a little bit about that and other aspects of door sales in March. And then in April, we're going to be talking about residential construction. It could be new construction, it can be remodeling, but there are all sorts of things that go into a construction claim, part of which under the Texas law requires a demand letter to be sent that has 60 days to respond. The defendant, home builder or repair man or whatever gets ability to inspect the property and offer a way to fix it if they want to. So we'll go into all of that in our April RCLA Second Saturday series. We hope that you find these monthly Second Saturday series on legal things very informative. And the last thing I want to do is remind you that we have upcoming now a podcast called Legal Grounds, where our Chief Marketing Officer, Alexis Gutierrez, and I will sit down, I think on a monthly basis, so we're starting at this point, and we'll kind of go over different aspects of law. It won't be so much the Second Saturday series where I'm sort of teaching you, but we'll go over questions and answers and things in the news regarding the law and those kind of things. It'll be available on the various types of podcast platforms, and I think you'll be able to get both video and then audio. We just want to do the audio. So we look forward to doing that. I think our first one will be in March. We look forward to you watching Legal Grounds and continuing to come to us every second Saturday for our Second Saturday series, Sanchez Law Firm. Thank you and have enjoyed the Super Bowl.